Hello, everyone. Shannon Smith with Key Title here, and I'm excited. I have Maggie Cromer from Midtown Property Law, and she and I are going to have a discussion about some things that we think might be helpful for you and your business. And Maggie, thank you so much for being here.
Thank you for having me. I'm so excited.
Yes, I thought we would keep this casual. Yeah. And maybe what you could do, Maggie, is just start out by telling us a little bit about yourself and your firm.
Absolutely. I will try to be brief about that. I started practicing real estate in 2015. I was actually a realtor before I got hired as a real estate attorney. And so I've seen kind of both sides of the transaction. And the connections I had from being a real estate agent is what got me the position at the real estate law firm that I got my first attorney position at. And so it was interesting kind of how everything just worked out. But I worked at that firm for several years. I'm now with Midtown. Me personally, I'm a mom of two little crazy boys. I was about to say minions. They're awesome. I am born and raised in Nash County. I'm North Carolina native. I spent a little bit of time in South Carolina because that's where my husband's from. But overall, born and raised in North Carolina. And I feel like I kind of stumbled on real estate. What a lot of people don't know about me is I used to be a singer. In my previous life, I studied vocal performance in college, decided I did not want to be a starving artist for my entire life, and just kind of, like I said, stumbled into real estate and absolutely love it. Love what I do. I love getting to the closing table, especially with my first-time home buyers, because the first time I ever bought a house, I was like, what just happened? I don't understand anything. And so I really like taking the opportunity to educate my buyers so that they feel comfortable and in control when they leave, because they often come in kind of nervous and don't know what to expect. But anyway, I love being a real estate attorney, and I particularly love working with my agents. So
that's great. Well, your background as an agent, I think, is super helpful. Yeah. And I know one of the things that we hear quite often is the agents don't really have a go-to attorney. And so what we try to encourage when they reach out to us is please try to find that one attorney that you can use as your go-to attorney so that you have that level of comfort throughout the transaction. I think what happens is so many times maybe the lender has an attorney that they work with, or a builder or somebody. And so the agent, it just goes with whoever is suggested just to keep the waters calm.
Sure.
But what ends up happening is they don't have that level of trust. They haven't built that rapport. So maybe what you could open up about a little bit is your relationships with some of the agents that you work with, some of the things that you've done with them in the past that could maybe help encourage some folks to send some business to you and build that relationship with you.
Absolutely. So first of all, to your point, I think it is really important for agents to get to know their attorney or attorneys, their lenders, their title companies. Get to know those people really well. When you have a closing where the agent and the attorney and the lender and the title insurance company are familiar with each other, it makes for a whole different closing experience. Even when issues come up, because you're going to have something come up on some closings, regardless of the circumstances. When those issues come up, when you have these people who have worked together and there's rapport and trust there, it's a lot easier to work through those problems. So I think just having those teams can be really valuable, because ultimately you will provide a better closing experience for your client. But one thing that I like to do for my agents, I go to agent meetings. I do lunch and learns. I do new agent orientation, because the purpose of doing all of that is I want to educate my agents as much as possible so that they can anticipate things and better navigate the closing process. if an agent has spoken to me about, what happens when an estate comes up on the seller side and they've got a listing where the person on the deed has passed away, they're better equipped to answer questions. Other agents either may not know what questions to ask, or in order to get the answers to those questions, they have to try to get in touch with the attorney that they may not have easy contact with. And closing attorneys we're very busy. We spend a lot of time in closings at the closing table, so we don't, returning phone calls can be difficult, especially in the way everything moves in this market. It's very fast-paced. So already having that kind of information and being able to provide like scenarios of, hey, I had this come up, this is something to be aware of. The more you know, the better prepared you can be. And I also, one thing I do with the agents I work with is I provide them my cell phone number. Agents work in the evenings and on the weekends.
That's awesome.
I get that. And that is, well, it's a tough reality about being an agent, and it takes a specific kind of person to be an agent. It's a hard job. Mm-hmm. It's a hustle. Mm-hmm. And I also tell my agents, if you have gone through the agency course and taken the exam, power to you, because that thing is hard. I have been there. It's awesome to just have passed. But having access to your attorney on the weekends when you're trying to get a contract in and you've got multiple offers and you need an addendum or something like that, it's nice to have access to an attorney on the weekend to try to turn that around for you. So those are just a few things that I do for my agents. It's all about, like you said, it's all about that trust and building those relationships. And they take great care of me, and I try to take really good care of them. So
that's wonderful. I know one thing that we get asked quite often is, could we do a title search? And I think what happens, we let our agent partners know that we can proactively look for prior title policies. And so we have an extensive database through our relationship with Investors Title, which we're very proud of.
Yes.
But there's only so much you can tell from a prior title policy, because there's a lot of things that happen from the time that title policy is issued to today. And so one thing that we talk about when I talk to agents about this is the importance of having that relationship with someone like you.
Absolutely.
So that a title search could be conducted and that you could offer your legal opinion, and that we don't render title without an attorney's legal opinion. So maybe you could talk about the importance of the attorney's legal opinion and how that might benefit us here in North Carolina.
Absolutely. So one of the unique things about North Carolina is we are one of, I can't tell you exactly how many, but only a few states in the entire country that where attorneys handle the closings. Most states, title companies would handle the closing. Obviously, I'm biased, but the reason I believe in what we do is when you're pulling all these documents and you're examining them and you're looking at how property is held between people, all of that has to do with the law, and it's an interpretation of how statutes are applied. And we literally look at statutes virtually every single day in this business. And so if you're having to look at a statute to determine how to interpret something that's recorded on public record, that is the practice of law. And so attorneys really should be the ones conducting these title searches and reviewing and certifying title. North Carolina has one of the lowest, if not the lowest, title insurance claim rates in the country. So that right there speaks for itself. It's proof that we're doing things the right way. And so the attorney is central in that closing process. If a listing agent has a listing where they want to be really proactive before getting it on the market, and they have a relationship with an attorney, they could reach out to that attorney for them to be able to take a look and say, yes, I think you're fine, given everything. I don't know. the attorney could potentially go ahead and certify title and charge like a title certification fee for that, or offer, not certify, but offer an opinion of title to the seller. More likely, they'd probably just do a review and give a thumbs up or a thumbs down. And then oftentimes the listing agents will even negotiate in their contracts for their preferred closing attorney to handle the closing if the buyer doesn't have a strong opinion as to who handles the closing. So it also, as a listing agent, could give you more control over the transaction if you can steer who is handling it, because when you have access to the attorney to get answers faster, it makes a difference for your client. But going back to North Carolina and being an attorney state, I think that it's important to know what the attorney's role is, because we get a lot of buyers who are coming from out of state. Raleigh and the surrounding area is attracting a lot of relocators and
international people.
We're like top 3 real estate markets in the world, I think, definitely in the country. We're one of the top in the country, and we have the most affordable housing prices. So even though we're seeing those housing prices go up, we're still the most affordable by far of all the major real estate markets in the country. So we're seeing all these people come in from out of state, and there's a very big difference in the role of the attorney in North Carolina versus states like New York. In New York, and I think New Jersey and Connecticut, the attorney actually plays a role that's more in line with what agents do in North Carolina. So one thing that agents want to do when they're working with out-of-state clients is set expectations for what their role is, what my role is, what your role is, and how the process is going to proceed. Most real estate attorneys will send out an engagement letter that says, we are just here to certify title. We're not going to get involved in contractual disputes. We're not litigators. We're title certifiers, and there was a reason for that. But we also try to have really good relationships with litigation attorneys because things happen in the real estate market, especially in our market. So we need to be able to quickly get those buyers in the hands of someone who knows how to navigate the court system and really handle those disputes well. But knowing what the closing attorney does is very important, and how it's different in North Carolina versus other states. So
that's very helpful. I think that is something that is really great, especially where, people might get keys at closing, like
Sure.
They don't understand that time.
That's a great point.
And different states handle escrow differently. And so,
Yep.
There's a lot of things that people come with from wherever it is that they come from and have an idea.
Sure.
And in order to provide the highest level of customer service from an agent perspective,
Absolutely.
the more of that you can talk about up front,
Absolutely.
the better. And then
Yes.
if they have questions and need additional guidance, you can do that before it gets to closing.
Of course.
Prevent the challenges around that.
That's a great point. And because in some states, it doesn't matter when the documents get recorded. They're like, oh, it'll happen eventually. No worries. But we're a state where the recordation of the documents is key. So definitely explaining that to your clients. And I think a really important point is with buyers. And I always tell my agents, tell your buyers to prepare for the worst and hope for the best. Because what you never want to do is have a buyer show up to closing on a Friday afternoon thinking, hey, I own a house, everything is done. And then something doesn't happen the way it's supposed to. Sometimes wire transfers don't happen because the Federal Reserve goes down. It has happened before. Or things like that, and you've got a buyer who's got a moving truck in the driveway, expecting to move in on a Friday afternoon, and it doesn't get recorded. And the sellers are the kind of sellers who are like, nope, we're not going to give them possession prior to closing. Sorry, they have to wait until Monday. And then your buyers have to make other arrangements. They have to stay in a hotel or find storage unit for 2 to 3 days. And so those are things that a knowledgeable agent can help prevent, like just what day you choose for your closing, what time you choose. Are you selling, and do you need those proceeds to purchase your house? I mean, there are all kinds of things that matter. And to your point, understanding this North Carolina specific closing process is helpful so that you can make those decisions.
Well, and one thing, this goes back to having that relationship again,
Yes.
because I know agents are like, I've got too much on my plate. I'm already thinking about too many other things. I don't want to have to be thinking about that sort of thing. I would rather have a go-to attorney that will be asking those questions up front, and then they can have that communication too. And so it's a team effort. And I think, the days of looking for the closest place to close and proximity to the property are gone.
Yes.
I think the more that you can take control, and I was an agent at one point too, so that we have that in common, where the more you can take control on the front end, the more at ease you can be throughout the entire transaction.
Absolutely.
And provide a better level of service for your customer and not have to get wrapped up in all the title side of things.
Yeah.
Like leave it to your team to do, and then you can be off working on that next opportunity. And
on the next opportunity or the things that you need to do for that closing. You don't have to get bogged down by the other things. There's trust there that those things will get done. Yes, absolutely.
And I think as time goes on, we're seeing that community, that level of trust, keeping things local, all of those things are becoming more and more important because we know we need to have each other to rely on. And I think that was my main goal for bringing you today, because I heard from agents that you were available on your cell phone and that you did, take the calls. And that's what everybody needs right now, is somebody they know that is going to handle it, and they don't have to be panicking or worrying behind the scenes that something is like the ball is getting dropped. So with that being said, I know you and I had talked about some scenarios too briefly about some title things that might be helpful to, obviously, there's things that you can control, there's things you can't control. But, some of the topics out there, and I know sometimes agents will hear about this when they have a guest come in for a sales meeting, but I think some of the things that you had highlighted, I thought would be really helpful to touch upon briefly, like judgments against sellers. So that was one thing that you'd mentioned, and we hear about that. We hear about, we think that there was a HELOC that was out there, but the lender went defunct, so they don't think they owe it. Things that are just alarming as a title person.
Absolutely.
So maybe you could talk a little bit about judgments against sellers.
Sure. Yes. So that goes back to the role of the attorney as well, and the interpretation of law. And the practice of law. So what judgments attach to real property is an interpretation of statute. So for example, if you have property that you have a husband and wife who are purchasing property together and they're both listed on the deed, if there is a judgment against the husband for credit card debt, that judgment is not going to attach to the property unless it's against both the wife and the husband. So that's one thing about owning property as what we call tenants by entirety. It's essentially marital property, and that property is protected from certain individual judgments. Now, there are some judgments that will break through that barrier, IRS judgments being one of them. Surprise, surprise, right? So IRS judgments do overcome tenants by the entirety. And then judgments typically will attach, if they do attach to property, they attach for a period of 10 years, unless it is a federal judgment, which sticks for 20. But oftentimes what we find is the sellers don't remember they have those judgments. Like a judgment comes up, someone owed money for a car, and something like GE Capital got a judgment against them, and they own the property alone. So that judgment attaches, and they've never made a payment on it. It was from 9 years ago, but we're still within that 10-year period. So it's often a surprise when the seller comes back, or when the attorney comes to the seller and says, by the way, you have a $6,000 judgment that has to get paid at closing. So that is something that comes up. As long as there are sufficient proceeds to pay it, it shouldn't be an issue. But really what I see more than judgments is buyers who obtained down payment assistance loans through like NCHFA. They don't make payments on most of the loans coming from NCHFA, the down payment assistance loan particularly. They don't make payments on those loans, and after a period of time, they are eventually forgiven. But those sellers will often sell the property before the debt is forgiven, and they forget that they have that debt. And it can be an $8,000 down payment assistance, or it can be $22,000. And I've had a seller who, we get to where we're disclosing the settlement statement to the seller, and they realize that they have $22,000 to pay to NCHFA. And again, as long as there are sufficient proceeds to pay it, it's not a title issue. It just has to be paid, but sellers often forget that they have those. Again, that goes back to agents being informed and knowing what questions to ask, like when you purchase the property, did you get down payment assistance? And then I'm trying to think if there's anything related to judgments.
Well, and what I threw out there was about a lien, about the HELOC.
Oh, right, yeah, home equity lines.
Those liens that are out there that may or may not.
Real estate attorneys very much dislike home equity lines. So they're a title trap. They are often a problem. I cannot tell you how many times I've had a closing come up where the seller used to have a home equity line on the property. The account is either inactive or closed, but it was never canceled of record. The problem is with if it's a true revolving equity line, there's a really hard to get insurance over, because you could draw on them at any time up to a period of 15 years, and then of course there's the repayment. And so equity lines can be really difficult. The more recent they are, the more difficult it is to try to resolve them. To your point, oftentimes the lenders that issued those equity lines in the past are no longer. Tracking down someone who's willing to cancel them of record is a pain. I had a seller, sweetest man in the world, who stopped by every single branch he passed while he was, whatever he was doing, wherever he was going. If he saw this particular branch or this particular bank, if he passed a branch for that bank, he would stop in and talk to somebody to try to get a resolution for this equity line deed of trust that had not been canceled. And every time he would stop, he would send me an email and say, hey, I stopped again, didn't get anywhere, I'm still working on it, I promise I'm doing my best. And I so appreciated everything he did, and he was so nice. But it's really frustrating for sellers, because it shouldn't be an issue, but it is an issue, and sometimes they can be really hard to resolve. So that would just be something I tell consumers is, if you pay off a mortgage or an equity line and you want it closed, make sure you tell your lender to cancel it of record, because otherwise tracking somebody down 15 years later is going to be really difficult.
Well, and that's super valuable for an agent when they go in for a listing appointment. That's one of the things, when they're going through the checklist with the seller, by the way, do you have an equity line?
Absolutely.
What does that look like? And so that's information that if they've got a good relationship with you,
Absolutely.
this is a HELOC. This
Yep.
is one that we're not sure about, you
Yep.
know, so that's very helpful information. And then going to what you were talking about, the judgments with the spouses and, you know, just why, you know, when and where spouses sign, when, you know, how they should join title, spouses in general. I think that would be a great thing for you to maybe talk about too.
Absolutely. So I laugh because this comes up so often. We have a rule in North Carolina, 1 to buy, 2 to sell. I think every agent everywhere knows that rule, but I'm not sure they really understand the practicality of it. So when someone is married and they purchase property, if they do not have like a free trader agreement in place or some kind of memorandum of agreement in place, then any real estate that they purchase, even if the spouse is not on the deed with them, that spouse automatically has an inchoate marital interest in that property. And so when the purchasing spouse sells, that spouse is going to be required to sign. It is the most common conversation I have with sellers. There are different ways to tackle it. If someone wants to buy property and not have that marital interest attached, you can either execute the free trader agreement and have that recorded in advance. You can purchase the property and then your spouse can sign a deed relinquishing that marital interest. It's called a marital quitclaim deed. And by the way, it's quit as in I quit, not quick as in speedy. A marital quitclaim deed. If you ask a family law attorney whether that spouse has an interest, they're going to give you a different answer because they're looking at it from a family law perspective and pursuing a divorce. And we're looking at it from a title insurance perspective. And what we are trying to avoid is your spouse later, if you're going through a divorce or separation, your spouse coming back and trying to claim a monetary interest from that property as, if they're a dependent spouse, if they need that additional income or whatever the case may be. I'm not a family law attorney, not well versed on it, but a spouse can claim an interest in the other spouse's property during the divorce. So that's what we're trying to avoid, is that spouse is saying they're not going to come back and claim an interest in it later. So a real estate attorney will always have the spouse sign unless there was something already in place that allows them to avoid that signature.
That makes sense.
And that includes inherited property. It doesn't matter how you got it. If you purchased it, if it was gifted to you, if you inherited it, your spouse is always going to have to sign when you sell.
Extremely valuable information. And then, let's see. That takes us right to estates.
Yes.
So one of the things that you'd mentioned was what to do when an estate is involved. You know, if you know you're going out and you already know that there's an estate, what are some things that agents can look for, be listening for, questions they can ask to prepare so that it doesn't become an issue closer to closing?
Yes. So my biggest recommendation would be for the sellers to work with an estate administration attorney when there's an estate involved, because obviously we're talking about real estate. So that means that there is a substantial asset. So I do recommend estate attorneys when possible, but I understand that people try to save money. So the court system actually offers all kinds of pamphlets for people who want to try to navigate it alone. But essentially, if you have property where someone who is on title has passed away, now there are some circumstances when their death is, you're not going to have to worry about an estate. If you have rights of survivorship, or if it's what we spoke about earlier, tenancy by entirety between spouses, that has rights of survivorship as well. So when you have those rights of survivorship, the person who passes away, their interest goes to the survivor automatically.
So what about, if I can interrupt you, what about in that scenario that you talked about where there was a free trader agreement? What would happen in that scenario?
Okay, so the only way for the rights of survivorship to exist is if both spouses are on the deed at the time and they are married at the time. If that's the case, then if nothing else is specified, like if it doesn't say John and Jane as tenants in common, if it just says John and wife Jane, then that is tenancy by entirety, and those rights of survivorship are built in.
Great. Thank you.
Absolutely. So if you take property just John Smith and your spouse is not on there, there's no rights of survivorship. So if John Smith passes away, let's say John Smith had a will. In order for the property to pass under that will has to be validly probated in North Carolina. So ideally, you probate the will in the property in the county where the property is located. But sometimes you have people who have multiple properties in multiple counties. So if you have a will that's been probated somewhere in North Carolina, you can always file a copy with the county where the property is located. I believe it's an exemplified copy to establish that notice, because that's what we're all about, is putting people on notice when it comes to real estate, because it's public record and we need to be able to trace who owns it. So you have to open up the estate file. So if there's a will, it has to be probated. One thing that has to happen before closing can occur is notice to creditors has to run. Basically, the fiduciary of the estate has to publish in a newspaper, and the newspaper has to meet certain statutory requirements, a notice to creditors saying, hey, this person has died, you have a certain amount of time to come forward and make claims on the estate. And so that has to happen before you can sell the property as far as title insurance is concerned. Couple of things about if you die with a will. Okay, well, who signs the listing agreement? Who signs the contract? It depends, because every will is different. So some people will automatically have the executor of the will or of the estate sign the paperwork. Well, the executor may not actually have the authority to do that. If the will gives the executor the power of sale, then the executor could sell the property without involving any of the beneficiaries or the heirs. Whereas if you have a will that says, I leave all my property to my children in equal shares, those children, once that will is probated, that it acts as a deed. That's the conveyance, is the probating of the will. Those children now own that property. And really that listing agreement needs to be between those children and the listing agent. Now, if you're within that 2 years of the date of death, and if the estate is still open, then the title insurance company is going to require that the executor join in that sale. So you will oftentimes have the fiduciary, the executor, sign as well as the heirs. But the people who technically own it are the people that the property was devised to in the will. So that's an important thing for listing agents to know, is if you have an estate, I highly recommend contacting your favorite real estate attorney to verify who needs to sign, and they're going to need to review the will in order to make that determination. Side note, interesting little thing I had come up recently for a client of mine. His grandfather had his will done in 2012. In 2013, his daughter passed away, so he updated his will. So he had a 2012 will and then a 2013 will. Both were submitted to the county, but the certificate of probate was issued on the 2012 will by the county. So I had never seen that happen. Both wills were filed in the estate file, but the earlier will, which should have been revoked and not probated, was the one that got issued the certificate of probate. So that was something we had to deal with. So just,
Interesting.
I've never had that happen, but I thought it was worth noting that if you have multiple wills, make sure you get the right one probated.
The most recent.
The most recent one probated.
And,
yes.
and that just goes to show, too, that the timing in everything. And
Yes.
again, going back to the searches
Yep.
and why it's so important to have the attorney
Absolutely.
conduct the title search.
Yes.
And then they can update title as it gets closer to the
Yes. closing
if there is
Absolutely.
anything unusual that comes up, or, we know probate, anything
Yes.
around estates can change. So that's one of the many things that can change from
Yes.
the time that title is certified to
Yes.
closing. So
Yes.
even that period of time, it's important for you guys to be heavily involved. And
Yes.
what I always say to agents when they reach out to us is, we work with you based on your opinion, but we don't have the whole file in front of us.
Right.
So there's a lot of things that we don't see,
Yep.
don't necessarily know about.
That's exactly
and so I'm really glad that we have this opportunity to talk about
Yeah.
some of the things
Absolutely.
and why it does really benefit the agent to
Yes.
have that go-to person.
Absolutely.
And we love working with Maggie.
I love working with you guys.
You will have an opportunity to work with some more of our partners.
Absolutely. That would be
and
great.
we appreciate your time today.
Sure.
We look forward to doing more work with you. And hopefully you guys will see Maggie in some of your offices soon.
Yes,
We'll try
I'd
to
love that.
get that coordinated. But thank you again for your time. We really appreciate it. And we
Sure.
look forward to doing more work with you soon.
Thank you for having me. I appreciate it.
Thanks, Maggie.